Good afternoon, and welcome to session number 2 of Acquisition 102, Part A. This course is being delivered by the ODOT Office of Real Estate, and your instructors for the course are Wayne Pace and Sean Crawford. This is Victoria Beal with the Ohio LTAP Center, and we're so pleased to be able to assist in hosting this delivery in a virtual manner. Couple of housekeeping items, and then we'll get things turned over to Wayne, who's going to be your instructor for the day. First off, we do ask that if you have questions, please put them in the question pod, and we'll be monitoring that, and we'll make certain to get your questions over to the presenters throughout the presentation today. Secondly, in the handout pod, we have for you the slides from today, and we also have an index of handouts that'll be discussed during the training. So I don't believe there's anything else I need to go over at this time. So Wayne, are you ready?
I'm ready to go.
Thank you.
All right, welcome everybody. This is session 2 for the Acquisition 102. Sean talked yesterday on the first session of Acquisition 102, so I'm going to do the talking today. Today, I'm going to have a kind of a brief overview, and then it'll be new for some. And we're going to be talking about the contract of sale of purchase, which is out of the 5201.05 out of the real estate manual. We're going to be talking about the administrative settlement, which is out of the 5201.10. And then we're going to have a knowledge check. And then I thought I would do just 2 little small case studies, just kind of show you what we've got on the case studies here. There's just 2 small ones. There's nothing difficult on those. All right, we're going to get started here with the contract of sale of purchase document. This will be the same type of teaching that you would see in our regular face-to-face classes that we would have. All right, when we're dealing with our contracts, contract of sale of purchase documents, this ODOT's policy that the contract of sale of purchase document is used anytime that there is a fee taking. The districts have that discretion to use the contract of sale of purchase if there are any easement takings from the property. Now, with that being said, I know that we always look at utilizing the contract of sale of purchase for fee takings, which we'll get in what a fee taking is. But every now and then, when you are acquiring an easement, district acquire easements, sometimes the easements and the property owner has a little bit more complexity to it. And when it leans to the level of a little bit higher level of complexity, the districts have the ability to use the contract of sale of purchase just to acquire the easements as well. We don't see very much of that, but the districts who do have that tool in their toolbox for their own purposes. When we're looking at fee takings, we're looking at what is known as the acronyms for WD or WL. That means a warranty deed or a warranty deed with limitation of access. In parentheses, that'll be the warranty deed, and the V represents an LPA. And then the WLV is the warranty deed with limitation access when dealing with LPA. Of course, our contracts have been pre-approved by the Transportation Attorney General's Office, and it's in compliance with our 5501.31 of the Ohio Revised Code. This is when, of course, all of our forms are prescribed by the AGO. One of the things that's very important, our contracts cannot be amended without prior approval of the proposed changes by the Attorney General, except to those procedures when we're doing some changes of the contract and it's considered kind of nominal by the district management, where then it doesn't require any type of AGO approval. Sometimes, and you'll see in our contract, you'll see like an item E, which is in section 1, and they can put something in there that would be very minor that will not be legally intrusive to our contract. Okay, the AGO also has created some standardized language that is made to be inserted into the contract. That is owner retention of improvements, which is known as our RE 220-1, a boundary survey expense, the RE 220-2, and the next one is our land exchange. That's the RE 220-3. And then the boundary survey expense and land exchange, which is the RE 220-4. We'll talk about some of those a little bit later in the presentation. Now, ODOT uses two different types of contracts. We use the contracts that's for the purposes of acquiring for our state highway projects. And the first one we use is our RE 220B. That is when it's a contract to sell or purchase when we're acquiring buildings. So anytime we're acquiring a building like a house or something of that nature, that's the type of contract we're going to use. Number two is the contract to sell or purchase without building. So we're acquiring a vacant land piece. That's what or an improvement. That's what we're going to look at acquiring for the improvement, and that's the RE 220-L. On the RE 220-B is used when there is a building that's being acquired and that the building is owned by a fee owner. Buildings that you see is defined as a structure that's having walls and a roof, and it includes residential structures, residential dwellings, barns, and sheds. And you would only, if you're not acquiring the building, then you're not going to be using this form, but you only use this form when you're acquiring buildings on the RE 220B. The second form is the RE 220-L. Now this form is used when there is a fee taking. Of course, we define the fee taking as a WD or WL within the parcel series, and there is no buildings within the take area. If there are non-buildings that we're going to be doing, we're going to be acquiring improvements with regards to acquiring for that particular, or the use of this parcel, or the use of this contract. So the RE 220L and the instrument will be sufficient documentation to show that we're going to be acquiring the purchase of that improvement. Now, when you get into the item D, where it says the tenant-owned improvements that's located within the parcel series that's being acquired by the bill of sale, to that document of the purchase of the improvement from the tenant and the RE 220L documents for the purchase rights from the underlying fee owner. So just keep in mind, we're acquiring two things here. We're going to be acquiring a bill of sale for the improvement that's owned by a third party, and then the underlying fee owner for the land itself. We're going to be acquiring those property rights there. And then once again, use this only when you're acquiring improvements, and not when you're acquiring a building. Okay, for ODOT projects, you always want to use our contract forms that appears on the Office of Real Estate webpage. The same thing that we have for our consultants, we have the contract forms on our webpage as well. Every now and then, ODOT will have to make revisions to our forms. It could be our instruments, it could be our NIAGFO, as well as the contract forms. We always make those revisions, and we post those revisions to our current web page. One of the things that you got to keep in mind is that you do not use local drives, because all the time due to the fact that you will not catch those new revisions when we make those changes. For LPA projects that we use, those LPA projects, we use the 800 series forms when it deals with the LPAs. If you look at what would be the difference between the two of our RE220 and the 800 series, basically the 800 series forms has the ODOT language taken out of it where it pertains more to LPAs, and that will be your difference. Okay, we're going to get into just a little bit of an overview of the contracts here. We're not going to dive into the language because we would typically save that for our instrument class where the Attorney General's office accompanies me as we teach this instrument class together. But we'll cover a couple of the highlights that are in the instrument that would be pertinent for you to know and which you'll be filling in. So when we take a look at our first section, this is our first section here that, of course, anything that's highlighted in gray for the contract to sell or purchase for the RE220B, of course, you're identifying the parcel listing, the county route and section. That's what that represents, the seller's name. All of that is basically made for you to enter that data into those fields. Also, the under item 1 for price consideration, this is where you would put the FMVE for that particular parcel. Also, in the event that you are in the process of settling a parcel under administrative settlement, you would also put the new administrative settlement there. That would be the only document for that particular piece. You put that in there. Under item E, if you remember, I have mentioned that sometimes the district managers can put certain things in the particular contract that doesn't involve the Attorney General's office. This is the particular area that you would put that in, as well as the pre-approved language that goes in that section as well there that I had showed you. There was 4 levels of pre-approved language that the Attorney Generals had approved. Number 2, this covers the area of estates and deeds and transfers. It describes a lot of different other areas that are within there. When we get into section 3, it gets directly into limited access. Some of your supplemental instruments that will be needed and necessary acquiring. Section 5 gets into the warranty of title. It must be free and clear of liens and encumbrances. That paragraph discusses that. Section 6, elimination of other interests. And then section 7 gets into the change in the no change in the character of the property. Section 8 gets into a very important piece that once you come to an agreement with the property owner and the property owner exercises and signs the agreement prior to ODOT, which is the purchaser, then it is very important to know that the purchaser, which is ODOT, has 20 days to sign that contract and get a copy of that contract back to the seller or to the property owner. That's very, very important for that. In the event that it goes past that 20 days, you do risk the possibility of coming out of contract. And it could, and I use the word it could, mean that negotiations could reopen again. So you want to make sure that once you get the contract signed by the property owner and then your district authorized personnel, which is generally your district real estate administrator, signs that contract within the 20 days, and a copy of that contract goes directly back to the property owner. Section 10 covers closing in the event that the seller is contacted about the closing. You have 10 days of trying to get that particular parcel closed. Same way when you're looking at closing a complete closing or the transition of the document, which I give 120 days from the date of the last signature of that contract. Now, if you notice, those particular areas are grayed in, and it does provide flexibility for the districts to make those changes if they see it's necessary, because a lot of times it just doesn't work in the way that you like it. So we've made it accommodate those particular situations and gave the flexibility for the dates to be, for the time frame of the dates to be changed. Of course, item 11 talks about the surrendering of possession of the structure. Then the typical language here that it gets into the binding agreement in those areas. I will like to go back and talk about just one brief thing. Let me just swing back here. Under the area of item 11, it talks about the possession of a structure that's occupied by the seller. This is where it gets into if you're dealing with a property owner and you're acquiring their home or some type of a structure. And this is where we get into the days that may have to be changed, because they give 30 days for the property owner to be moved out from the premises. That doesn't always work that way. So we have to make that flexible as well, to whereas work in conjunction with acquisition and relocation, that when the property owner would be able to vacate the premises. Also, you'll see an amount in that area. That amount represents a holdback amount to ensure that the property owner will be able to move out of that particular structure. And then once they've moved out of that structure, the holdback will then be released to the property owner. We get into other areas of the binding agreement, and then of course amendments of contracts, and then the signature will follow. This here, we get into the signature page of the RE220. And on all of the contract to sell or purchase documents, as well as instruments, we have an instructional page that basically is the acknowledgement form, which is known as the RE244C through the RE249C. And that would be used for the correct owner of interest that would be acquiring for that, signing for that particular contract or for that parcel. And we'll be going through what those series mean. And then of course, the authorized signature for authorizing the signing for the director, and it's to be notarized. Next are the highlights of the RE220L, the contract for sale or purchase for real property form. Now the terms of the RE220L nearly are identical to what's on the RE220B. And there, of course, there are some exceptions. Under the section 2, it's a little bit different there, because on the first section it talked about, on RE220B, talked about buildings and structures. In this case here, we're going to be talking about, and it highlights here, about the improvements. And so this is when you're dealing with improvements that are going to be impacted. So your vacant land and your improvements such as a sign, fencing, things of landscaping that could be impacted. So this is how we kind of identified and addressed it in this matter here. On item 7, it's the same. We've identified, it talks about on item section 7, it references only the area of the improvements as well there too. The same in section 11. In the physical area there, the physical possession of the improvements. The other one was the physical possession of dealing with buildings and structures. And so we're covering these aspects here with regards to the improvements on these particular sections. And then on the last page of the RE220L, it mirrors the same information with the inserting of the RE244C through the RE249C. On your left side of the screen, this is the page that shows the acknowledgement forms that would be inserted in. On the right side of the screen, it shows the RE244C for the acknowledgement form for the property owner would be signing. That particular form of the RE244C would be inserted into the area where you see the instructional page that's on your left side of the RE220L. Once that's inserted, and then the instructions, which is that's bolded in black and underlined, would be deleted and removed. And then you'll see the final product of what that would look like, showing that now you have the in witness whereof is now inserted in. The grantor is located in this particular area here where the property owner was signed and date. Earlier, you would notice that there was the form numbers that were on that particular form of the RE244C that is deleted and removed. Now we get into the acknowledgement forms of the contract to sale and purchase. These are the acknowledgement inserts that are used for the contract to sale or purchase. We have the RE244C, and this is when we're dealing with persons that are unmarried, or we're dealing with persons that basically the spouse at one time, we were dealing with that, with the spouses refusing to sign the dower and refuse to sign. And so that's what the purpose of this particular document, this acknowledgement was for. The RE246C is used when you're dealing with more than 2 or more landowners. This is if you have a married couple. You're dealing with that. You can also add that on here. Or you're dealing with multiple owners to the parcel. So you would be able to capture the property owners onto that RE246C form. The RE247 form is used when you're acquiring from corporations or limited liability companies. Of course, if you're acquiring from a corporation, you're going to be asking for a resolution. And then for limited liability companies, you're going to be asking for an operating agreement. The RE248C, this form is used when you're acquiring partnerships like general partnerships, limited partnerships. This will be the particular form that would be used for having them to sign that particular acknowledgement form. The RE249C, this form is used when none of the other forms are applicable, and you have to have the AGs provide assistance and guidance with that particular type of acknowledgement. For example, it could be a trust or the trust of a trustee. Sometimes those particular documents can get a little bit confusing. In some areas can be complex. The Attorney Generals will provide assistance in using this form and helping you complete the completion of that particular form. Now we come into some of the pre-approved standard paragraphs for the contract to sell or purchase. And if you remember, we talked about things like that. We're talking about the new inserts. These inserts here are with regards to the owner retention. And the purpose of the owner retention is when ODOT has agreed that the seller may retain an improvement. So if you remember on the front page, on the first page of the contract to sell or purchase, this had an item E. And on that item E, this is where you would insert the language or insert this document directly on item E. Once you've inserted that document on item E, you would then delete out all of the bolded area that's underlined. Next is your boundary survey expense, which is known as the RE 220-2. And this is when ODOT has agreed to compensate sellers for boundary survey expense. This, of course, is controlled by the county auditor, and if the county auditor is requiring a boundary survey expense, there's various options that ODOT has provided with regards to assisting with the boundary survey expense. That's picked up more in detail in our Acquisition 103 course. All right, here is when we're dealing with when ODOT has agreed to a land exchange, and this is inserted into the form. Every now and then we might run across a situation where ODOT and the property owner are dealing with acquiring some property, and the property owner is interested in a piece of property that's within the project corridor. This particular document is used for that. Once again, it goes into item E, and the same thing repeats. Once it's inserted, the bold and the underline is removed. Here's the last insert, which is known as the boundary survey expense and land exchange form. And then this is, of course, a combination of both when ODOT has agreed to compensate the seller for the boundary survey, and a land exchange would be involved. So this kind of houses two in one. This is where we take a look at the signature section. Of course, the signatures of the representative must be notarized. ODOT representative have the signature authority for the director of ODOT and sign the contract on behalf of the director. So the persons now have the signature of the director, and the signatures are kept in Chief Legal Counsel's office. We start with the District Real Estate Administrator, and it has an acronym of the DREA. The District Capital Improvements Administrator, the CPA. Your District Deputy Director, and the Administrator for the Office of Real Estate. These signatures cannot be delegated at all with regards to the signatures of dealing with the contract. That ends the contract of sale and purchase section. Victoria, are there any questions?
Not a one. You have just riveted them.
Oh, okay.
Great information.
All right.
I'm sure they were just following along, so.
I'm sure. Okay, let's go to the next area. The administrative settlement. This administrative settlement that we have here is located in our real estate section of the manual, which is the 5201.10. This is the citation coming out of 49 CFR, the Code of Federal Regulations. And the main thing about this, instead of me reading this whole thing, is that the property, the purchase price of the property may exceed the amount offered just as to justification when reasonable efforts are negotiated. So the main thing here is that if there's just compensation that is out there and the FMVE has been made, and the event that the property owner is not in agreement and can provide, number one, justification, this citation allows for an administrative settlement to be done. And that's the purpose of this whole citation here. out of this code. Districts have that may settle the acquisition for the amount greater than the established FMV under these conditions, and it must be justified. Now, when we're looking at justification, this is kind of interesting. One thing we try to stay away from is boilerplate language. Boilerplate language basically is something that you would use on a repetitive basis, and it does not really reflect the issue of why the property owner is needing or is requesting for a higher dollar amount. One of the things to keep in mind is that every parcel is unique. They have unique issues. And so with having unique issues, those unique issues will come into win in acquisition, appraisals, project management issues, litigation. So circumstances that basically are applicable to that particular property owner, that's what you need to be writing that justification for. And then that way we know that that is justification for that particular parcels. Understand that sometimes you run across situations where property owners are unable to provide the justification. You still write down what they're saying. And then you work with what you have, basically. Where do you document the justification? Well, you document the justification. We have this document that's called the RE22, and the RE22 basically is justified information that comes from the valuation of that RE90, the value finding, as well as the summary appraisal report. That particular document has all of the history on it, so nothing gets deleted out of that. Your value analysis. On the value analysis block, this is where you assign the front of it with written justification of the comments on that section. Sometimes the comments that you might have to write your justification for, you might have enough space underneath, or sometimes you might have to revert to the back of that the value analysis or the next page of the value analysis. There is no RE22 that's necessary for performing an administrative settlement on a VA. Your negotiator notes. Your negotiator notes are very, very important. On our session tomorrow, we're going to talk about why that's so important and how much information goes into that, and which is very, very important to know that those negotiator notes are very important, especially when reading, to make sure they're succinct and easy to read and provide plenty of justification in it. All right, this is the RE22, which is used for when you're doing the appraisal and the review of the appraisal. Now, with this, you'll have the administrative settlement located in this particular area. So what happens is that if you know that the realty specialist knows there's going to be a administrative settlement, then what happens, you go into the RE22, create a separate column that says administrative review or settlement at the top. You're going to recreate the numbers that you see that's going to go across here, recreate what's located in this area here. And then in this area right here, where it says other, you're going to create and put in the information for the administrative settlement dollar amount. And with that being said, then once that's done, the district real estate administrator will then sign off on that administrative settlement. All right, here's the value analysis. Now, keep in mind, this is the older version of the value analysis. And with the older version of the value analysis, we have not had an opportunity to upload the newer version. The newer version was just launched, I think, April the 15th of 2020. So we will have the newer version in our next year's class when we put this on. Of course, if we put it on again, we will have the newer version already in place. But nevertheless, on the VA, this is where you put the information that's relative to the administrative settlement. It will require the signature at the bottom, as well as the FMVE, the additional amount, and then the total settlement. Now we're going to get into just a flow chart here. And with this particular flow chart, just kind of give some of the basic flow of how it goes for the administrative settlement. So for the administrative settlement procedures, we're going to be looking at, when you're looking at on the left side is the FMVE established based on the appraisal. On the right-hand side is the FMVE established based on the waiver of the appraisal, the VA. So just keep that in mind as the VA on your right side. So as you look at the arrow as it goes down, the property owner makes a counter offer. The same thing for the VA that you see on the right side. The negotiator documents the proposed settlement on the RE 60-1, the same thing that goes in on the VA side as the arrow reflects. Depending on the settlement amount, either the REA or the Office of Real Estate Administrator will make the or the high dollar panel. Well, that's only for the appraisal. Very rare, and nor have I never seen it, has that ever happened for the VA. So basically, that's just an arrow that's just placed there. Moving down, the REA signs the RE22 in the administrative settlement block. Same thing that happens that I just showed you on the previous form, where the REA will sign the value analysis for the settlement. The negotiator documents the settlement on the RE 60-1. Same thing that goes for the VA. And then the REA needs to justify the settlement, and that's done on the RE 22. Same thing that's done on the value analysis. One of the things to keep in mind, notice at the bottom, and I've highlighted it, that the offer letter is not amended. The offer letter stays the same. I will go back. The contract to sell or purchase, though, it will be amended to make sure that settlement is reflected in the contract. All right, we're going to get into some settlement authority. For the settlement authority, the district real estate administrator, capital programs administrator, and deputy director have $20,000 or 20% over the FMVE, whichever is greater. The negotiator has authority up to $1,000 over the FMVE. Administrative settlements that are greater than $20,000 or over the 20% of the FMVE, the settlement request is sent to the Office Administrator of Real Estate. The RE 65 is used, and a copy is made of that along with the negotiator record. That document is very, very important for the real estate administrator to make sure that he understands the full and complete reason for the administrative settlement that's going to exceed the district's limit. Of course, this becomes a part of the parcel file. Now, the settlement authority for the administrative of Office of Real Estate. This was changed. We recently had a chart flow showing various calculations of percentages. We've changed that to make it more simpler because the bottom line is still represented the same thing. It's $3 million. And so rather than going through all the gyrations of the calculations, we just kept it a little bit on the simplistic side. So that does reflect in the current manual today. The district REA is responsible to justify the settlement. So that means that when a request comes in for administrative settlement from the realty specialist or for contractors that are doing the work for ODOT, make sure you have good justification and the reason why the dollar amount is needed. Supporting documents for the administrative settlement. This is where we're getting into the RE65. This comes in from the district real estate administrators, the RE60-1 for the negotiator notes. ODOT's valuation, that's what we're looking at, either VA or appraisal. Property owner's justification, that's very, very important. That should also be a part of the notes where you're getting the information of what the property owner's concerns are as well as relating your concerns. So it should be a two-way conversation that should be seeing on those notes. Here is an example of the RE65. This is just a sample of an RE65. Actually, this is the one that I did a while back ago. Major justification had to go into this, and as you would notice, a lot of explanation had to take place of the parcel itself, the reason for the parcel, and the reason for the administrative settlement. The continuous next page basically is just more information that gets filled in for that RE65. Once again, more information. If it's available, make sure that you put all of the information in, especially when you're dealing with the property owner's valuation of estimates as well as ODOT's valuation of estimates to the best of your ability. Then it requires a signature. And if the recommendation can be settled, yes or no. And that's generally coming from the real estate administrator. For the settlement authority, that's over $3 million. The high dollar panel handles that on administrative settlement and case settlement reviews. And the persons that consist of the high dollar panel is the chief legal counsel, administrator of the Office of Real Estate, the deputy director for Division of Engineering, or his designee. For LPA authority, with federal funds in the right-of-way, up to $3,000 over the FMVE. Once it hits over the $3,000 over the FMVE, the district must approve or review, and it has to work with their authority, which is $20,000 or 20% over the FMVE, which is greater. Once it exceeds that, basically it goes to central office real estate administrator. And I believe since Sean Hillman is the LPA coordinator, definitely he would need to be copied on that. So that way he can address that along with the real estate, the office administrator, central office. The LPAs may allow the notes of the consultant for the settling up to $1,000 as well, the negotiator to settle for $1,000. When we're dealing with no federal funds in the right of way, the LPA has full settlement authority, but the district needs to ensure that the compliance is met with regards to that as well. All right, we're going to go for knowledge check, and Victoria, I'll let you take over.
Okay, we're going to go ahead and put the first of the knowledge check questions up. And Wayne, do you want to go ahead and show the first one on your screen as well?
Well, there you go.
Okay. I'm going to launch this for everyone. And we'd like to have at least 80% of you respond to the question before we close it out. So ODOT's policy requires the contract for sale and purchase to be used anytime there is one of the following: fee taking, utility taking, easement taking, or none of the above. So if you would please get your vote in. We are not recording which way you voted, so you don't have to worry about that. Just go with your gut on this one, and then we'll be moving through the other questions. Okay, we've got 80%, so I'm going to close this out and share the results. We had 94% that said fee taking, 4% said easement taking, and 2% said none of the above.
Okay.
So I'll hide that, and you can let us know what the answer is.
There it is. All right, we'll move on to the next one.
No problem. And I did get a message from one person that said that it wasn't allowing them to answer the poll question. So that's okay. We'll let you off the hook this time. So, all right, can you go ahead and advance to the next one? All right.
Okay.
And on this question, select the type of contract forms used on ODOT projects to acquire fee simple parcels. First option is RE220A and RE220B. Next option is RE220Z and 220L. The next one is RE22L and RE22B. So let me open it up. All right, we're getting close to 80%. Put your vote in, please. All right, great. We're there. I'm going to share the results, and 86% chose the last option, RE22L and RE22B. 14% chose the first option. Nobody chose the middle option. So I'll hide that, and you can share with them. There you go.
I'll move to the next one.
Great. Let me share that poll. ODOT has pre-approved standard paragraphs for the contract for sale and purchase, and this is true or false. They're responding great.
Okay.
You guys are the best responders out of any webinar I've ran today, and I've ran quite a few of them. So, all right, 96% said true and 4% said false. Let's see who's right. I've hid my, there you go.
Okay.
Now this next one, I'm going to read it off your slide before I put the poll question up because it didn't all quite fit in my poll box.
Oh, okay.
This representative ODOT is responsible for signing the contract for sale of purchase, must have signature authority for the blank of ODOT. Let me put the poll up and then I'll read the answers. Realty Specialist Manager, Director, Secretary, all of the above. And they're voting.
That's good.
Yep. I think they're really thinking about this one because the voting is going a little bit slower here. All right, I'm going to close that down, share the results. We had 28% said Realty Specialist Manager, 66% said Director, and 6% said all of the above. So I'll hide that.
Okay.
Okay.
Ready?
Yep. The answer is
Director.
There you go. I felt like the guy that does one of those game shows. Okay. All right. District offices may settle an acquisition parcel for an amount greater than the FMVE if justification is provided by the property owner. Launch on the poll, and you just have to tell us true or false. There's not quite so much angst in answering this one. The voting's going quick. All right, I'm going to close this one down and share the results. We have 90% that said true and 10% that said false.
Okay.
So the answer is, there you go.
Okay, next
All right.
one.
The district real estate administrator, capital programs administrator, and deputy director have the authority to approve administrative settlements up to blank. I'm going to put the poll up now, and it'd be $5,000 or 5% over the FMVE, $10,000 or 10% over the FMVE, $20,000 or 20% over the FMVE, or none of the above. Now, this is the point which I'm sure a few wish this was e-learning so they could scroll back through the slides
Yes.
to get an answer. All right, here we go with the results. We had 2% that said 5,000 or 5%, 4% chose 10,000 or 10%, 84% chose 20,000 or 20%, and 10% said none of the above.
Okay.
So the answer is, here you go, 20,000 or 20%. All right. And I believe this will be our last knowledge check question.
Yes.
The negotiator has authority to approve only $100 over the FMVE. True or false? This is the quickest they voted. I'm closing it down already. All right, I'm sharing. 4% said true and 96% said false. So I'll hide that.
The answer is?
I tried to hide it. I'm still seeing the poll question. Do you want to stop sharing your screen for a second and then reshare? Sorry, this is that little hiccup we ran into yesterday too.
Okay, stop sharing.
At least it waited. There we go. And then reshare.
Okay. Let's see where our reshare is at. Show.
It's that little bump out on the side. Oh, there you got it. Good. And the answer is false. All right, that's it for my portion here. It's back to you.
All right. Let's see here. Let's get it to go again. Okay. All right. All right. The last part of the series of this webinar, we're going to do just a couple little short mini case studies, just something to kind of for new people, how they would see certain things. And then all of you probably that's seasoned, that's been through it already, but they're nothing complex, but something that we thought we would just share with you. All right, this particular project is going to be a Franklin 62 10.93 parcel 52WL and 52WD. There is our PID, which we have of 76523. There's the address of the location of the property owner and the owners, Melvin E. Smith and Melissa Smith. There's no mortgages. And the FMVE is $21,500. You are a realty specialist assigned to this acquisition. Parcel 52 involves a parcel take having the highest and best use of a commercial. The NIAGFO, which means the Notice of Intent to Acquire Good Faith Offer, was presented to the Smiths for $21,500. Within 30 days, Mr. Smith contacted you with a counter offer in the amount of $25,000. And you stated that the counter offer is the basis. He stated the counter is the basis on the recent comparable sales in the area that were not in the appraisal. Mr. Smith provided you with a copy of the comparable sales to take back to your manager for determination. The realty specialist manager reviewed the recent comparable sales information and determination was made. So here's a question, which I'll be answering it. Can this administrative settlement be approved by the district staff? The answer is yes. Here is the computations. So it was determined with that computation. Of course, all of this controls with the realty specialist manager. And the reason why is because it does not exceed the $20,000 of the 20%. and is covered in the section of the manual of 5201.10b. Once the counteroffer has been determined, will it be necessary to change the NAGFO to match the counteroffer? You'd be surprised how many questions I get of that. The answer is no, because the NAGFO is used to document the offer of the FMVE to the property owner, and it is not amended to reflect the administrative settlement. And then there's a citation in our manual that reflects that. All right, this is our last case study. This is out of the Delaware 23, 10.93, parcel 13 WD. There's our PID. There's the address location. The property owner is Mr. Morgan Bailey. He is a single owner, no mortgages, and we have an offer FMVE of $2,350,000. And here's the scenario. You are the realty specialist assigned to this acquisition. Parcel 13 involves a total take having a highest and best use of commercial. The NAGFO was presented to Mr. Bailey for $2,350,000. Within 10 days, Mr. Bailey contacted you with a counteroffer in the amount of $3,100,000. He said the offer that was presented to him did not include recent comparable sales in the area. Mr. Bailey provided you with a copy of the comparable sales. Can this administrative settlement be approved by the DREA? The answer is no. Here's the computations. Comes over to 32%, but better than that, it does go over the threshold, also over the office administrator of the Office of Real Estate. So therefore, who can approve this administrative settlement? And that's the high dollar panel. They would be the ones that could approve the administrative settlement. Who are the members of that high dollar panel? Which is Chief Legal, the Office of Real Estate Administrator, Deputy Director, and the Division of Engineering or its designees. All right, that concludes the session of Acquisition 102, Session 2. Are there any other questions?
There are not, but I'm guessing that they're just digesting all this information and they're going to store your questions up for tomorrow.
Oh, I'll be anxious to hear them.
Be ready. So. All right, everyone, thank you so much for your time today, and we're going to go ahead and sign off. When we do, there's going to be a survey, so please take a moment and fill the survey out for us. We'd appreciate it. All right, everyone have a great rest of your day and stay safe. Bye-bye.
Thank you.
Bye-bye. Thank you. Still there?